Good morning, everyone, and welcome to another edition of Foundation 101 podcast by Team MHQ. I'm joined this morning, as usual, almost by Kath Zagatti. Kath, good morning.
Good morning.
And what we are trying to achieve through this modest weekly podcast is shine a light on the impact on the foundation tool on regional and domestic structuring and restructuring. Foundation have been introduced 3 years ago to the region and have really gained substantial momentum over that period with the ability of structuring, consolidating, protecting a number of different asset classes throughout the region. And today we will be looking at a couple of the parties that are involved in respect to a foundation, namely the founder and the council member. So let's look into this right away with you, Kath. This is a foundation. It looks almost like a company, but it's different because it doesn't have shares, if you remember from our previous podcast. So what it has is bylaws and a charter. It is recognizable, registered, and it can also hold all these different asset classes that we have here. So very similar in spirit to a company, yet with noticeable advantages. Now, if we look at the key parties around this tool, we see 4 of them. One is the founder, and we'll talk about it slightly later. He is the one that creates the spark that, in our jargon, would blow this balloon that is the foundation. The second is or are the council members, and we'll talk about them in detail. They are in charge of the day-to-day administration of the structure. And then you have 2 more. The beneficiaries, which are the people that are designated by the founder or at a later stage by another party as being the ones that benefit from whatever proceeds are distributed by the foundation over time. And then this weird little party on top, the guardian, which is akin to a protector and a trust, a bodyguard of sort, the oversight position that is there. We'll talk about this next week with Celia Titouni. But today, we focus on 2 of these only, the founder and the council member. So my first question to you, Kath, if we are zooming in on this little party here on the left side, is what is the founder's role in a foundation?
Yes, so aside from founding the foundation, the role of the founder is also to determine how the foundation will be managed and controlled, who will be the members of the foundation, like the council members, the beneficiaries, as you said, or as the case may be, the guardian, and how the proceeds of the foundation or the assets themselves would then be allocated or distributed. So the founder has freedom to specify any conditions, restrictions, and rules of the foundation's constitutive documents, which are the charter and the bylaws. And also the founder can prepare and execute letters of wishes to give further guidance to the foundation council and the guardian. So whenever a foundation has more than one founder, then in this case, the co-founders will have to take these decisions jointly, unless they had agreed differently among them. And it's also important to note here that the founder does not necessarily need to be an individual. It can also be a corporate structure.
So if I hear you, a lot of flexibility there, lots of liberty and defining whichever way one wants to aim the foundation. You mentioned you can have co-founders, you can have corporate founders, all of which can have their own benefit depending on the strategy you want to have with respect to the use of the foundation. So if that is freedom, that is rights, does the founder have any obligations?
Yes, it does, indeed. To register the foundation, there are certain information that must be provided by the founder, which are the foundation's name, the purpose of the foundation, which could be succession planning, asset management and protection, or charitable and educational purposes, the initial capital or the assets to be settled onto the foundation. Also, the founder must determine who will be the first 2 council members of the foundation, who will be the beneficiaries, what would be the procedure for designating the beneficiaries. Also, who have the right and the powers to change the charter and the bylaws, which can either be retained by the founder by means of the reserved powers, which we'll be discussing in a while, or vested in the guardian or the council members. And lastly, the founder must also determine what would be the procedure for dissolving the foundation and the distribution of the assets following such dissolution.
Interesting. We often talk in fiduciary structure of the reluctant settler, of the person that says, yeah, I know it's necessary, but I do not want to give too much control to a third party, which is a perfectly understandable fear for entrepreneurs who during their life are in control. So my question to you, if a founder sets up such a structure, settles some of his assets onto it, and is or is not one of the council members, how much control can he keep? How much rights can he safe keeps over the term of this foundation?
Okay, so basically, there are two ways wherein the founder can keep rights and control over the foundation. The first option is the founder himself being appointed as one of the council members, which would then enable him to be in charge of the day-to-day management of the foundation. That's the first option. Now, if the founder doesn't want to be appointed as one of the council members, he can retain certain special powers, which are the reserved powers that I said before, which will also allow him to control key decisions on the management of the foundation without jeopardizing the integrity of this entity. So, as a rule, the reserved powers cannot be inherited or passed on to the founder's heirs unless this is clearly stated on the charter and the bylaws of the foundation. And also the founder has the option to appoint a substitute founder who will then be able to exercise the reserved powers upon the passing of the founders. So the reserved powers can address many different issues, and I'm going to give you a couple of examples. The founder can retain powers, for instance, to modify the charter and the bylaws of the foundation, to change the beneficiaries or the entitlements to these beneficiaries, and also to appoint and dismiss council members, guardian, and so on. So the list can be longer as the founder wishes.
So if I hear you well, a lot of flexibility on the founder side to be involved day to day, to have oversight power, to really keep control in the same manner as if he or she was setting up a holding company. Now, one of the purposes of setting up a foundation and settling the assets is to protect them. So is too much power sometimes an issue? How broad should these power be, or is there any red flag in terms of how much is too much?
Yes, there is. So the excess of the founder's control can potentially trigger tax requalifications, requalification and angles for attacks against the foundation and the foundation's assets by third parties, which could be creditors or even the founder's forced heirs. So we always recommend that legal advice is sought when creating the foundation and setting these reserved powers, taking into consideration the purpose of the foundation, the founder's faith, and his place of domicile.
Understood. Now, let's turn our attention to the control function. And from what I understand from you, this is no longer done primarily by the founder, it's done by the council member. So talk to me
Correct.
about this function, this body, the council.
Okay, so the foundation council must be composed of at least 2 council members, which are initially appointed by the founder, as we said before. And subsequent council members can also be appointed by the founder if he has reserved the powers to do so, or by any third party empowered to appoint council members by means of the foundation's constitutive documents.
Understood. And what is their role on a day-to-day basis?
So basically, the role of the council members is to administrate and manage the assets of the foundation in accordance with the foundation's charter and bylaws, as well as in accordance with the letter of wishes left by the founder. So similar to a board of directors in a company, the council members do not hold personal title to the foundation assets, and therefore they don't have personal liability vis-a-vis the foundation, save of course in case of negligence or fraud committed by the council members. On the other hand, and as opposed to a board of directors, the council members do not have shareholders or investors to report to. So they have more independence when it comes to managing the assets of the foundation. But I must say here that this independence is not absolute, as it can also be limited to the reserved powers of the founder or the guardian, as the case may be.
I see. So it seems to me like this is something that is reasonably accessible to someone that is, let's say, involved in a business savvy, perhaps already sitting on the family board as a family member. So point me out to some of the responsibilities that one should be aware of before accepting this duty, because often, as we see in practice, it is split between the family and professionals.
Correct. So as we said before, a council member has the duty to manage the affairs of the foundation in accordance with the charter, the bylaws, and the letter of wishes. So this means that the council members shall only exercise the powers that have been conferred to them by means of these three documents that I just said. And in case the council members go beyond such powers, then they can be found liable towards the foundation's members or third parties. And it's also important to state here that the council member is expected to act honestly and in good faith in the best interest of the foundation, exercising independent judgment with reasonable care, skill, and diligence. So we always say that it's a good added value to engage professionals to act as council members to guarantee regulatory compliance and high level quality of management of the day-to-day affairs of the foundation in view of these professionals' expertise and knowledge on succession planning strategies and asset management and protection.
And with the added benefit that the founder could actually keep the reserve power of substituting the council member if he or she was not satisfied with their services. So it's something that is gives a lot of flexibility and control to the founder in terms of ensuring compliance, yet keeping control over who and how this is being managed, unlike in a standard trust, for example. Very good. So now we have hopefully shine a little bit of light on two of these parties, the founder, the council members, which are key in the setup and running of the foundation's affair on a day-to-day basis. Next week, we'll turn our attention to two of these other bodies, the guardian and the beneficiary. Kath Zagatti, thank you very much and have a good week.
Thank you.